and I will call your attention to 3 counts of murder in the first degree, and would share with you that the potential punishment for each of these 3 counts include punishment of up to life in prison or death.
Death penalty is officially on the table for Jeremy Best, the Idaho man accused of murdering his wife, infant son, and unborn child.
We call death penalty work the brain surgery of criminal law. It's the most complicated thing there is.
The brutal crimes carry a severe punishment that could be difficult for the defense to combat.
No matter how mentally ill you are, that doesn't make you categorically ineligible for the death penalty.
The heartbreaking case has a laundry list of shocking details, from an apparent mental health break to a kidnapping, statewide manhunt, and eventually triple murder. The story begins on November 29th, when 48-year-old Jeremy Best was found naked, walking through the aisles of a Swan Valley, Idaho general store. The Bonneville County Sheriff's Office responded to the scene, where Best was reportedly taken to the Eastern Idaho Regional Medical Center for a mental health evaluation. He was released later that night. The next day, on November 30th, Victor, Idaho Dispatch received a disturbing 911 call. When they responded to the scene, they found Best's wife and her unborn child dead. According to a criminal complaint, Best killed, quote, Miss Callie Randall Best, a human being, by shooting her in the back and or right breast and or right side and causing her death. Missing from the scene was Best's 10-month-old son, Zeke Best. A statewide Amber Alert was put out, along with a warning that Jeremy Best was armed and dangerous. It was days later, on December 2nd, when investigators caught up with Best about an hour west in Idaho Falls. Someone called 911, reporting a man in a sleeping bag on the side of the road. When officials got there, Best was naked and allegedly delirious. Officers took him into custody and also found the body of 10-month-old Zeke in the woods nearby. Best appeared in court for the first time just 2 days later, on December 2nd. He appeared virtually without a shirt.
We're on the record. This is case number CR 41-23-877, State of Idaho versus Jeremy Albert Best.
Best was later bound over to district court, where he entered a not guilty plea to all charges.
I will ask you, Mr. Best, with the aid of your counsel, what your intentions are today with regards to your plea. Is it to enter a plea of guilty, not guilty, or to stand silent, wherein the court would enter the not guilty plea on your behalf? Mr. Archibald, have you had that conversation with your client?
Yes, Your Honor. He's authorized me to enter a not guilty plea on his behalf.
It was then that talk of the death penalty first came up.
Your Honor, I'm okay either way, so long as a status conference is set within 60 days, or at the conclusion of the 60 days, rather, so the state can make a determination whether it intends to file the notice of death penalty. And if the death penalty notice is filed, then I would anticipate a trial setting over a year out. Typically, our mitigation and mental health experts want at least a year to prepare for a trial.
Fast forward to February 28th, when Teton County prosecutors announced their intent to seek the death penalty in Best's case. To break down what all this means, we spoke to Temple University law professor and death penalty expert Jules Epstein.
So we're talking about an enormous expenditure of money, an enormous expenditure of time, in a world where it's pretty darn clear the death penalty, having a death penalty doesn't deter other people from killing. It certainly doesn't deter people like this defendant, who apparently have a mental illness. They're not thinking, my goodness, if I do this, I might get executed. I'm not sure what they're thinking. So that's the added, if you will, big picture thing about the death penalty that needs to be thought of.
Epstein says there's a variety of reasons why a prosecutor would pursue the death penalty.
Prosecutors are elected officials. So some of them are doing that because it fits in with getting elected. Some of it are doing it because they sincerely believe this is the moral and just thing to do. Some prosecutors designate a case a death case or death eligible case because it gives them more leverage towards working out a guilty plea.
As far as what goes into a death penalty trial, Epstein says there's a specific process.
A death penalty trial is really two trials. Trial number one is, are you guilty of first-degree murder? Or whatever degree of murder it is that in Idaho makes you death eligible. If the jury votes not guilty or guilty of a lower crime, it's over. If the jury votes guilty of that higher level crime, then you go into a brand new trial, which is, should this man be put to death?
When announcing the intent to pursue the death penalty, Teton County Prosecutor Bailey Smith put out a list of 10 statutory aggravating circumstances. It's up to the prosecution to prove just one of these points to yield a death penalty verdict. Among the aggravating circumstances, the prosecution's belief that each murder was, quote, especially heinous, atrocious, or cruel, manifesting exceptional depravity, and that Best has, quote, exhibited a propensity to commit murder, which will probably constitute a continuing threat to society.
Okay, so the first thing under Idaho law is that the prosecutor has to do something, which they've done here, and that's called notice. The idea is that if there's going to be a death penalty case, the defense is entitled to notice so they can prepare. And the notice lists what are called the aggravating circumstances or aggravating factors. In other words, you could have 20 people commit a horrible murder, each commit a horrible murder. But unless one of these extra circumstances is present, it doesn't make it death penalty eligible. In this case, they've got 3 victims. So for each of the 3 victims, they've listed the same 3 aggravating factors. And then for factor number 10, they're claiming that this behavior shows that this man is prone to repeat. In other words, he's a danger in the future. All they have to do is prove one of the 10, and the jury then gets to consider death.
Now that the state made its intent known, Best's team will begin crafting a defense.
For the next months and months and months, if not years and years and years, what goes into this from the defense side is not merely looking at this case to say, gee, can we get him found not guilty? Or gee, can we get him found guilty of a lower charge? But you have to assume you're going to lose. And if I'm going to lose, what can I do to save this man's life?
Best is being represented by Jim Archibald, made famous in last year's Doomsday Cult Duo trial when he represented Lori Vallow Daybell. Epstein says Archibald will likely focus on Best's apparent mental health issues.
This man, and forgive this terminology, is pretty clearly some form of damaged goods. And that's horrible to say about a human. But what do I mean? There is a clear mental health breakdown component here. I don't say that to excuse the murder in any way. But this is someone who earlier that day was walking around, if I got it right, naked in a grocery store. Someone who was taken to a hospital, and although they released him, that doesn't mean he's not mentally ill. That meant that under Idaho's commitment law, right, which can be a fairly high standard before you say, hey, you can't leave, we're going to lock you up in this hospital and medicate you. He was treated or seen for a mental illness. When he's arrested, the first thing the judge does is approve a mental health commitment to assess whether he's competent. And the word competent doesn't mean you're not seriously mentally ill. It just means, are you with it enough to go to trial?
That means the defense will spend the near future digging into Best's history.
So this is going to involve, from the defense side, learning everything about this guy, from his coworkers, from the neighbors, past medical history. I don't know if he was ever in the military, whatever his background is, psychiatric workup, psychological workup, and then the whole family background workup. Is there any organic damage? Is this someone whose mother had fetal alcohol syndrome? You know, things of that nature. What we call mitigation is not meant to say, oh, this crime is less bad. It's not meant to say, oh, this person is less responsible. It says this person's guilty. But before we decide if he reaches that level of we've got to put him to death, is there anything in there that says maybe that's not just? And that's actually the word used in the Idaho statute. Would it be unjust to put a person in this condition to death?
But these mitigating factors alone aren't enough to guarantee that Best avoids the death penalty.
So right now in the United States, you cannot say, hey, no death penalty because my client is mentally ill. The US Supreme Court said there is that kind of a fixed line, okay? If the person is what we used to call mentally retarded, intellectually disabled, IQ below 70, things of that nature. No matter how mentally ill you are, that doesn't make you categorically ineligible for the death penalty. So it actually wouldn't be the judge. This would be presented to the jury. And the jury would take that information along with the aggravating evidence, all the mitigating evidence, and then vote. What should we do?
What the defense can do is collect the information about Best's mental health history and present any compelling findings to the state.
They can bring it to the prosecutor and say, hey, we have some more data. Here's some more information. Here's a very credible report. And some prosecutors will say, I get it. We will withdraw the death penalty notice. If that happens, the trial goes forward just without the added risk of death penalty. Or that may be step one towards a guilty plea, no death penalty.
Epstein says jurors will likely hear from some mental health experts during the defense's case, but that won't be the bulk of the testimony.
The best defense will be 99% non-experts. Because jurors, if I come in and say, oh, I'm Professor so-and-so, I'm not sure anybody's going to listen to me. But if the guy's neighbors and priest or pastor or coworker or someone he was in the military with or someone he grew up with, or the local cop who said, you know, we've had this stuff a few times where he's really been out of his mind. And you give all that, and the fact that he doesn't have a criminal history before this, which I believe is accurate, and that there were a lot of positive things this person did. Then you bring in the experts, if you will, to tie the ribbon around the package and say, let me tell you medically what this means.
So you talked about the testimony there for the defense's side, and that always gets me wondering, could we possibly hear from the defendant? Do you think in this case it would be wise if the jury were to hear from Jeremy Best himself?
Having never met him and not knowing his mental condition, I don't know. Let me add a couple of complicating things here. I am assuming, but I don't know this, that he's going to be medicated if he has some psychological problems. So medication dulls the affect. So I'm not sure if a medicated person is speaking, if that's going to reach the hearts and minds of people. That's really hard to do. Number two, I'm not sure what he can say. Not knowing him, I don't know what his story is. Number three, if there are other ways to get in that he feels remorse, maybe the doctors. You know, the first thing when I interviewed Jeremy, he burst into tears. Maybe a prison guard is going to say he sits there at night crying. Somehow to communicate to the jury that he is sorry is an essential.
If the jury finds Best guilty and votes in favor of the death penalty, an execution wouldn't come right away.
There would be at least one appeal of his case. We call that the direct appeal, which is after you lose, you appeal. When that appeal is done, if you haven't gotten any relief, and again, I'm not certain of Idaho practice, so I'm talking in general, there's generally a second round review where now the lawyer's conduct is re-examined. Did they miss anything? Did they make any errors? Then it may reach a point of going for federal, what's called habeas review.
Just last week, the state of Idaho planned to carry out an execution for convicted serial killer Thomas Creech. The process came to a halt after a medical team couldn't get access to Creech's veins to administer the lethal injection. Epstein says a delay like this comes with the territory of a death penalty case, and it could mean additional hurt for family members of the victims.
Some people, and I'll be clear, I believe this, feel because the death penalty is so complicated and has so much review built into it, it's sometimes a lot better for the survivors of the victims to not have a death penalty because the case ends a lot sooner. A death penalty case takes on a life of its own, I will say properly so, because we call death penalty work the brain surgery of criminal law. It's the most complicated thing there is. And the more complicated something is, the more there's a risk of something going wrong, and then we have to do it over again. And the survivors live through that again and again and again.
Creech's execution would have been the first in 12 years in Idaho. It's also sparked a debate about a recently passed law there that would reinstate the firing squad. I know that there's a lot of talk about the firing squad in Idaho. Does any of that play into this case potentially?
Not yet, because you don't get to that until you are ordered to face the death penalty. Is it something that some juror might have read about and might be in the back of their minds? You bet. Is it something a prosecutor might say and look at and say, my God, I don't want to go through this spectacle again? Look at how that family suffered. Is it something the family members are going to say, we don't want to go through that? Or is it going to have the opposite effect? I don't know. Right now, whether you can, I hate to use the word successfully, but successfully execute someone is a legal decision different from whether a jury may legally vote for the death penalty. Because this is a death penalty case, it's going to take a lot longer before a trial may occur than if it were not a death penalty case, which has its own wear and tear on people. And because it's a death penalty case, it's going to cost that small county a ton more money because of those experts, because of the kind of thorough digging one has to do into the life of this person and the life of his predecessors.
Best is due back in court on March 14th. We reached out to the Teton County prosecuting attorney for this story, but have not yet heard back. Reporting for Law and Crime, I'm Sierra Gillespie.